First, I would like to begin with Senate Bill 1343, which changes California's sexual harassment training requirements for every business in the state. The California Fair Employment and Housing Act makes certain employment practices unlawful, including the harassment of an employee directly by the employer or indirectly by agents of the employer with the employer's knowledge. Senate Bill 1343 requires an employer that employs 5 or more employees, including temporary or seasonal employees, to provide at least 2 hours of sexual harassment training to all supervisory employees and at least 1 hour of sexual harassment training to all non-supervisory employees by January 1st, 2020, and once every 2 years after that. I want to repeat that. Every employer in the state that has 5 or more employees has to provide at least 2 hours of sexual harassment training to all supervisory employees and at least 1 hour of sexual harassment training to all non-supervisory employees by January 1st of 2020. Senate Bill 1343 also requires the Department of Fair Employment and Housing to develop or obtain 1 and 2 hour online training courses on the prevention of sexual harassment in the workplace and to post these on their website. So you should be able to start downloading these classes from the comfort of your dealership. Senate Bill 1343 also requires the department to make existing sexual harassment posters and fact sheets, as well as the online training courses available to employees and to members of the public in specified alternative languages on the department's website. So this training will be available in several languages. Starting January 1st of 2020, an employer with 5 or more employees shall provide at least 2 hours of effective interactive training and education regarding sexual harassment training to all supervisory employees and at least 1 hour of classroom or other effective interactive training regarding sexual harassment to all non-supervisory employees in California within 6 months of the assumption of their position. So this training must take place within 6 months of any employee that you hire at your dealership. An employer may provide this training in conjunction with other training provided to the employees. So, for example, you might be providing training on some type of new dealership software to all of your employees, and you'll be allowed to provide the sexual harassment training immediately before or after the software training, as long as the required time periods are met. The training may be completed by employees individually or as part of a presentation and may be completed in shorter segments as long as the total hourly requirement is met. So if you're not able to provide the minimum amount of training in one time setting, you can provide the training to your dealership employees over the several training sessions as long as each time period is met for each employee of your dealership. After January 1st, 2020, each employer shall provide sexual harassment training and education to each employee in California at least once every 2 years. So the training is going to need to include information and guidance regarding federal and state laws concerning the prevention and the steps that are necessary to correct sexual harassment and the remedies available to victims of sexual harassment in the workplace. The training and education will need to include practical examples that are aimed at instructing supervisors in the prevention of harassment and must be presented by trainers or educators with knowledge and expertise in the prevention of harassment, discrimination, and retaliation. It is imperative that you keep accurate records of each employee that has completed the training to ensure you are compliant with this new state law. We are going to have an entire section later on in the course, and we're going to show you exactly how to set up a harassment training course at your dealership. So that training program will be covered extensively later on in this training course. Senate Bill 1300 was passed and changes California's discrimination and harassment law. The California Fair Employment and Housing Act prohibits various actions as unlawful employment practices established by the United States or the state of California. The California Fair Employment and Housing Act makes it an unlawful employment practice for any employer or any training program leading to employment that is to engage in harassment of an employee that is obviously common sense. The California Employment and Housing Act also makes harassment of those persons by an employee other than the agent or supervisor unlawful if the employer knows and fails to take immediate corrective action. So if an employee of your dealership is harassing another employee with your knowledge and no corrective action has been taken, then a law has been violated. Under the California Fair Employment and Housing Act, the owner of a dealership may also be responsible responsible for the acts of non-employees with they harass employees. If the owner of the dealership or your supervisor, sales managers, or any employee knows of the conduct and fails to take immediate and appropriate corrective action. So just as an example, if a customer is harassing a salesperson, you would need to take some type of corrective action. Later in the course, when we cover how to set up the sexual harassment training course at your dealership, you're going to learn the importance of developing an effective reporting method for your employees, so your employees will have an easy way to report harassment directly to you. I want to clarify with you that Senate Bill 1300 states that an employer may be responsible for the acts of non-employees if they harass employees, such as salespersons. So you'll need to be very aware of this new law, because most of us have several non-employees in our dealership every day, and that would be our customers. You must be prepared to intervene if you ever become aware of any non-employee, such as a customer, harassing an employee, such as a title clerk, sales manager, salesperson, or even a lot porter. So you definitely need to be aware of that. Next up, Senate Bill 826 changes the number of female board members that are required on publicly held corporations. The bill we're getting ready to discuss may or may not affect the operation of your California dealership. If your dealership is not a publicly held corporation, this bill will not affect you. However, the bill ensures different levels of diversity, and diversity is obviously an important component to any California business. Senate Bill 826 requires a domestic corporation that is publicly held and whose principal offices are located in California to have a minimum of one female on its board of directors no later than the close of the 2019 calendar year. Before the close of the 2021 calendar year, Senate Bill 826 increases that required number to 2 female directors if the corporation has 5 directors, or to 3 female directors if the corporation has 6 or more directors. Senate Bill 826 requires the Secretary of State to publish various reports on its website that will document the number of corporations that are in compliance with the new law. The bill also allows the Secretary of State to impose fines for corporations that are not in compliance, and would provide money from those fines to be available to obviously offset the cost of administering this new law. So before the end of the 2021 calendar year, a publicly held domestic or foreign corporation whose principal executive offices are located in California shall comply with the following board member requirements. If the corporation has 6 or more directors, the corporation must have a minimum of 3 female directors. If the corporation has 5 directors, then the corporation shall have a minimum of 2 female directors. And if the corporation has 4 or less directors, the corporation shall have a minimum of 1 female director. And by the way, female means an individual who self-identifies her gender as woman without regard to the individual's designated sex at birth. Publicly held corporation means a corporation with outstanding shares listed on a major United States stock exchange. So if you're a very large dealership that is publicly traded, this law does affect you. I want you to be aware that failure to timely file board member information with the California Secretary of State's office will result in the amount of a $100,000 fine. For a second or subsequent violation, the fine will be in the amount of $300,000. So if your dealership does fall under this category, it would be extremely expensive if you are not compliant with this law. If your dealership is not publicly traded, which I'm sure would be the majority of dealerships in California, this law will not affect you. But as stated earlier, a diverse workforce is a very important component of any California dealership. Next, I want to discuss with you a new law. It was passed by Senate Bill 1500 that prohibits discrimination against service members. A person shall not discriminate against a member of the military or naval forces of the state of California or the United States, because California law prohibits various types of discrimination against a member of the military or naval forces because of his or her membership or service, including discrimination with respect to his or her employment. So the law also prohibits an employer from discharging a person from employment because of the performance of any ordered military duty or training, or by reason of being a member of the military or naval forces of the state of California. California law also prohibits a person from refusing entrance to any member of the Army or Navy of the United States or military or naval services of California because that member wears the uniform of an organization to which he or she belongs. Existing law also provides criminal penalties and civil remedies for violations of these laws. So Senate Bill 1500 extends the protection against discharge from employment to members of the Federal Reserve components of the Armed Forces of the United States and members of the state military reserve. So this law has been expanded. Senate Bill 1500 also prohibits refusing entrance into specified places to a member of the armed forces because that person is wearing a uniform of the organization to which he or she belongs. By expanding the scope of a crime, this bill would create a state-mandated local program. A business who provides lending or financing or brokers lending or financing, such as a California dealership, shall never discriminate against a person with respect to the terms of a loan or financing, including a finance charge, based on that person's membership in the military or naval forces of the state. Also, I think this law is very self-explanatory and basically common sense. You cannot keep a person from entering your dealership because they are a member of the military, and you may not discriminate against anyone when it comes to financing because that person is in the military. Assembly Bill 2392 changes vehicle towing and storage. Assembly Bill 2392 sets reasonable rates for vehicles that have been towed and stored, and many dealers in the state also operate a towing company. A towing company and a dealership are two businesses that certainly complement each other, and they basically go hand in hand. And if you tow or store vehicles, this law will affect you in the operation of your dealership. Under California law, when a vehicle has been towed and stored, the owner of the vehicle may only be charged a storage fee the first 15 days of storage, and after the first 15 days, only for any time after 3 days have lapsed after written notification has been given to the owner. AB 2392 requires the fees charged for towing and storage be reasonable. Assembly Bill 2392 lists reasonable charges for fees that are presumptively unreasonable, and the bill also requires that fees charged for towing and storage are explainable. California law grants certain rights to a person whose vehicle has been towed and stored, including the right to retrieve personal belongings from the vehicle without charge, the right to pay fees by cash or credit card, and the right to receive an itemized statement, of all the charges. The law also requires any business to post the notice outlining the customer rights in a place that is visible. A person who violates the provisions is civilly liable to the owner of the vehicle. So if you are not compliant with this new towing and storage law, your customers could have legal recourse against you. Assembly Bill 2392 grants additional consumer protections, including requiring facilities to be open and accessible during normal business hours, authorizing payment of charges to be made by insurer's check, and allowing an insurance company or the owner of a vehicle to inspect that stored vehicle at any time during business hours. The bill also makes changes to the notice required to be posted at the storage facility. So now you will have to have your fees posted in your office area. You can find several companies that can provide you with pre-printed brochures and posters that will help you comply with this new law. Just type California towing and storage fees and access notice into your favorite search engine, and you'll be able to see several choices for your new posting. So on a final note regarding this law, any California dealer that does repair work but does not provide towing services is exempt from the requirements to post towing and storage fees notices in the office area. Next, we're going to cover Assembly Bill 375, the California Consumer Privacy Act of 2018. This is a major change to state law. Assembly Bill 375 grants a consumer the right to request that a business that collects a consumer's personal information, such as a dealership, disclose that information about what the business has collected. So a business is going to be required to provide the information to the consumer only upon receipt of a verifiable customer request. So if any customer requests the information, you will need to provide it. California is one of the world's leaders in the development of new technologies and related industries, yet the proliferation of personal information has limited Californians' ability to properly protect and safeguard their privacy. It is almost impossible to apply for a job, raise a child, drive a car, or make an appointment without sharing some type of personal information. As the role of technology and data in the lives of everyday consumers increases, there's an increase in the amount of personal information that is shared by consumers with businesses. California law has not kept pace with these developments and the personal privacy implications surrounding collection, use, and protection of personal information as well. Many businesses, such as dealerships, collect personal information from California consumers. They may know where a customer lives, how many children a customer has, health information, financial information, social networks, just to name a few. The unauthorized disclosure of personal information and the loss of privacy can have a devastating effect for individuals, ranging from financial fraud, identity theft, and unnecessary cost to personal time and finances, and can also lead to damage, emotional stress, and even physical harm. People desire privacy and more control over their information. So California consumers should be able to exercise control over their personal information, and they want to be certain that there are safeguards against the misuse of their personal information. It is possible for a business both to respect consumers' privacy and provide a high level of transparency to their business practices. So beginning on January 1st, 2020, businesses that receive verifiable consumer requests from a consumer to access personal information shall promptly take steps to disclose and deliver free of charge to the consumer the personal information that is required by this new law. The information may be delivered by mail or electronically. So if your customer requests the information that you have obtained regarding that customer, say for example through a motor vehicle sale or a loan application, you must provide the information to the customer at no charge. You must provide information to the consumer at any time, but you will not be required under this law to provide that information more than twice in a 12-month period. Assembly Bill 2237, which involves corporate records. I want to give you a very brief overview of this law change. Assembly Bill 2237 allows copies of corporate records that have been lost or destroyed to actually be used for inspections by shareholders. The California General Corporation Law requires records and minutes of proceedings of shareholders and the board and committees of a board of any domestic corporation and of any foreign corporation upon written demand of the shareholder be made available for inspection. So if your dealership is a corporation with a required board, any shareholder is allowed to request records and meetings from any board meeting at any time. Sometimes original board meeting minutes might have been lost or could have been destroyed. So what this bill does, it revises the law to permit, if the original records and minutes have been lost or destroyed, an accurate copy of those documents can be open to inspection at the corporation's principal office in the state. This bill basically permits a shareholder as an alternative to this procedure to request that you can give copies of the documents instead of the originals that were required by law just a couple of years ago. So I want to make sure we don't get this law mixed up with the previous bill we discussed, Assembly Bill 375, which requires you to provide all information for free. This bill will allow a shareholder of a corporation to request copies of minutes and board meetings of records so they can be charged for that specific information. Assembly Bill 2138 changes some requirements for licensing boards, which has oversights over dealer licensing. This bill is going to prevent any licensing board in the state from denying a license, such as a dealer's license, based solely on an applicant's failure to disclose a fact that would not have been cause for denial of license in the first place. The previous law provided that the licensure and regulation of various professions and boards within the Department of Consumer Affairs. The law also authorizes the board to suspend or revoke a license or take disciplinary license action against a licensee that's been convicted of a crime. So I want to explain. The previous law provided that a person shall not be denied a dealer's license solely on the basis that the person has been convicted of a felony if she or he has obtained a certificate of rehabilitation, or that person has been convicted of a misdemeanor, or she has met applicable requirements of rehabilitation as developed by the board. So the previous law also prohibited a person from being denied a dealer's license solely on the basis of a conviction that's been dismissed. So now, under Assembly Bill 2138, it revises those provisions to instead authorize a board to deny, revoke, or suspend a license, such as a dealer's license, on the grounds that the license has been subject to formal discipline or convicted of a crime, only if the dealer has been convicted of that crime within the preceding 7 years. Assembly Bill 2138 prohibits a board from denying a person a dealer's license based on the conviction of a crime if that record has been expunged, or if they've had rehabilitation, or that person has been granted clemency or pardon. The previous law authorized the board to deny a dealer license on the grounds that the dealer license applicant knowingly made a false statement or omission of material fact. So this law changes that regulation and now prohibits a board from denying a dealer's license based solely on the dealer license applicant's failure to disclose a fact that would have been cause for denial of a license. So this bill goes into effect on July 1st of 2020 and will actually allow more persons to apply for a dealer's license in the state, even persons that have had a felony. Assembly Bill 1976 changes lactation accommodations for California businesses. Assembly Bill 1976 requires an employer, such as a dealership, to make reasonable efforts to provide an employee with the use of a room or other location other than a restroom in close proximity to the employee's work area for the employee to express milk in private. Assembly Bill 1976 does not allow an employer to make available it does allow an employer to make available a temporary lactation location as long as it is not in a restroom toilet stall. So if the employer can demonstrate to the Department of Industrial Relations that this requirement would impose a unique hardship, the bill requires the employer make a reasonable effort to provide a room or location for expressing milk for employees that is not a toilet stall. So you are now required to provide a private area for any employee to express milk, and whether that location is permanent or temporary, the lactation area may not be a toilet stall. So you will have to ensure that you can comply by this law. Senate Bill 880, Workers' Compensation Prepaid Credit Cards. I want to give just a very brief overview of this bill. Senate Bill 880 authorizes an employer, such as a dealership, with the written consent of the employee to deposit disability indemnity payments for the employee in a prepaid credit card account that allows the employee reasonable access to an in-network automatic teller machine. So we cover workers' compensation for dealers in depth later on in the course, and this would allow you to deposit compensation into your employee's prepaid credit card. And as I stated, we're going to cover workers' compensation in depth for California dealers later on in the class. But this does allow those payments to be made into a prepaid credit card account. I want to go back a little bit and cover a couple of bills that were passed in previous legislative sessions that you will need to be aware of, including Assembly Bill 44, Workers' Compensation Terrorist Attacks. Assembly Bill 44 was passed back in 2017, and you need to be aware of this because it requires employers to provide immediate support from a nurse case manager to employees injured in the course of employment by an act of domestic terrorism. Acts of domestic terrorism can really present a unique issue for workers' compensation systems. So victims of acts of domestic terrorism whose injuries arise out of the course of employment are entitled to the full benefits of the workers' compensation law for all physical and mental injuries, which may include counseling or other mental health services. Treatment provided to all injured workers is provided by healthcare providers who are trained and qualified to treat those injuries. Because of the unique circumstances surrounding the number and severity of injuries that can be caused by a single act of terrorism, it is appropriate to provide workers with injuries that result from an act of domestic terrorism with additional advocacy services. The California Workers' Compensation Law compensates an employee for injuries sustained in the course of his or her employment, which we will discuss later in the course. But Assembly Bill 44 now requires employers to provide immediate support from a nurse case manager to employees injured in the course of employment by an act of domestic terrorism. The bill would make its provisions applicable only if the governor declares a state of emergency in connection with that act of terrorism. I also want to discuss Assembly Bill 46, Employers' Wage Discrimination. Very important that you're aware of this law. Assembly Bill 46 was also passed in 2017 and prohibits California employers, including licensed motor vehicle dealers, from paying any of its employees at a wage less than the wage paid employers of the opposite sex for a similar job. The law prohibits any employer from paying its employees at a wage less than the rates to an employee of the opposite sex for similar work unless the employer demonstrates that one or more factors account for paying a different wage. The law also prohibits any employer from paying any of its employees at a wage less than the rates paid to employers of another race or ethnicity of a similar job. So any employer that is paid a lower wage in violation of this law may file a complaint with the Division of Labor Standards Enforcement against your dealership and authorizes the Department of Industrial Relations to commence a civil action for the wages of the employee that was deprived because of the violation. You could also be charged interest on those wages and damages. So if your employee, they may actually seek back wages, interest on the back wages, and damages from your dealership if you paid a person of one sex or race a lower wage than another employee of a different sex or race. Also under this law, an employee that reduces the wages of any employee in order to comply with the law is guilty of a misdemeanor. So you cannot reduce wages of one employee to match the wages of another employee in an attempt to comply with this new law. And finally, I want to go back. I'm sure you're aware and probably already in compliance with this law that went into effect a couple of years ago. It was the Assembly Bill 516, which affected California temporary tags. As of a few years ago, California dealers are now required to electronically report the sale of a vehicle and issue a temporary license plate, or as we call them, a TLP, which is valid for up to 90 days. Also, as a reminder, when the customer receives their permanent license plate, they're required to destroy the temporary license plate. So you should always remind the customer to be sure and destroy their TLP when they receive the new license plate for the vehicle you have sold them. Remember, the old report of sale form's 5-day notice has now been eliminated. I'm sure you're aware of that. Assembly Bill 516 increased the document processing charge that a dealer may also charge the purchaser of a vehicle and authorized the imposition of an electronic filing charge for reporting vehicle sales and producing temporary license plates. The bill also authorized the DMV to establish contracts with qualified industry partners to provide the required reporting and temporary license plate services. So remember, the temporary operating copy of the notice of sale form is still required to be displayed in the window of the vehicle in addition to the temporary license plate. BPA participants may charge a document processing fee of $85 and non-BPA participants may charge a document processing fee of $70. As far as your customers are concerned, AB 516 prohibits a person from displaying a temporary license plate on a vehicle that was not issued for that vehicle and would make counterfeiting a temporary license plate a felony. The temporary license plates are required to be securely fastened to the vehicle for which they are issued. Temporary license plates may be applied to a vehicle that does not have two license plates, such as new motor vehicles, priorly licensed vehicles, and out-of-state vehicles. So everyone, be sure to remind your customers that counterfeiting a temporary license plate or displaying a temporary license plate on a vehicle that is not assigned to can result in a felony.